Picture this. After decades of hard work and dedication, you're about to be the first millennial to achieve the impossible, because you, my friend, are just a signature away from experiencing home ownership. You saved your crypto for the down payment, and now the bank has finally agreed to give you a loan, which is most likely the only thing you'll be passing on to your children, that, and some lucky genes, you beautiful animal. Just sign here. Congratulations! Here's the key to your new forever home. Go check it out. That's what he meant by forever. Now, if you've seen any horror movie ever, then you're likely familiar with the trope of a broke family somehow moving into a millionaire property only to discover that they are not the only tenants and how they cannot do anything to get out of this situation as it would bankrupt them financially. And while that makes sense from a movie perspective, I cannot help but wonder, could you legally get a refund if your new home turned out to be haunted? I got this idea while living in a more dynamic apartment where things would move on their own from time to time, back in law school. And as it turns out, there are not that many cases where people relied on the paranormal to get something done in court and actually did it. Okay, Mrs. Hester, you may now call your witness. Thank you, Your Honor. I now call upon the spirit of my deceased daughter to tell us how she was murdered. We understand your grief, Mrs. Hester, but the court cannot talk to the dead. Why not? She's right there. The story goes that in 1896, her daughter, Elva Zona Hester, married a local blacksmith from Greenbrier County, West Virginia, who also liked to go by the name Erasmus. Glad they didn't name a youth program after him. But all was not well and good in their marriage, as just a year later, Elva was mysteriously found dead in their home with the coroner ruling that she was a victim of death by heart disease. Not wanting to go down at the hands of death by heart disease, Elva's spirit reportedly visited her mother named Mary Jane Hester, I know, telling her how she was actually strangled to death by her now former husband. Mary Jane persistently voiced her story to the local prosecutor for hours on end, who eventually gave in, considering Erasmus's rather odd choices of refusing a proper autopsy of his late wife's body, which he then dressed himself, while also keeping the head covered. An exhumation and autopsy were ordered, which did in fact confirm that Elva's neck and windpipe were broken, with finger marks all around her throat. Like any good servant of the law, Erasmus's lawyer questioned Mrs. Hester extensively about her daughter's visit on cross-examination, hoping to prove her unreliable, but the tactic backfired when she stood by her story despite all the scrutiny. Given that the issue of the spectral visit was actually brought up by the defense, the judge found it quite difficult to instruct the jury to disregard the story, as many people in the community started to believe it. Nevertheless, Erasmus was found guilty of murder and sentenced to life in prison, although the Greenbrier Ghost, as it is now known, was never mentioned by the prosecutor nor the ruling, and that's for a very good reason. If the court was to recall MJ's story in its ruling, it would have only made that ruling more vulnerable to an appeal, as the court would have violated the legal standards for facts and evidence. How much this would have mattered in the face of less para and more normal evidence, such as the autopsy report, I guess we'll never know. But point is, any sentence, be it criminal or civil, needs to rely on facts and evidence, because until the ruling is formally revoked, it is viewed as the legal truth to the matter it analyzes. This is why most rulings follow the same formula. First there's the facts, or state of affairs, which essentially talks about what happened. Did Erasmus strangle his wife? Did Nestle kill a bunch of babies? Or did MAPPA fix the animation for Season 2 of Jujutsu Kaisen? The answer to two of those is yes, and Season 3 isn't even out yet. After we have the state of affairs, the judge is then tasked with applying the law to the facts concerning the matter at hand, but in order to do so, the facts need to be, well, factual, and served with supporting evidence. Now, do we know for a fact that ghosts exist? I do, but common sense would say otherwise. Regardless of how many episodes of Paranormal Witness you might have seen, cold hard science still hasn't proved the existence of ghosts beyond reasonable doubt, meaning that the law is not legally allowed to view anything paranormal as fact, which is why you can get convicted of harming someone with stuff like gypsy curses or cool warlock magic. You'd think that this pretty much answers the question this video opened with, as in, you cannot revoke a sales contract if your new crib is haunted because you can't legally prove it's haunted. So what am I going to go on about? Well, as much as I'd like to talk about how Bluebird is the best anime intro ever made, there is in fact a house like none other, which was indeed declared as a matter of law, haunted. Welcome to the village of Nyack it will be, New York, where an 18-room Victorian estate known as One Lavetta Place became sort of a local sensation thanks to its alleged paranormal guests. And this colorful roster includes a Navy lieutenant from the American Revolution still looking to kick some British ass in the basement, a spirit floating in the middle of the living room criticizing its aesthetic, and my favorite, an invisible alarm clock. That's right, the owner claimed that one of the ghosts would wake her daughter each morning by shaking her bed, going as far as to say that during spring break her daughter scolded the ghost saying that she did not have to wake up early and would like to sleep in, which apparently worked. For the 100th time, it's Sunday, I wanna sleep in on Sundays.
Sorry, I died on a Monday. I have to relive that moment for eternity.
How did you died rocking the bed?
We'll talk about it when you're older.
The house and the various ghosts within it were well known by the local people of Nyack, but these stories have gone beyond local legend. The house was included in a 5-home walking tour of Nyack and described in a November 27th newspaper as a riverfront Victorian with ghosts. During her time living at One Lavetta Place, its owner, Helen Ackley, not only spoke publicly about the ghosts, but she also wrote about them on both the local and national level, going as far as describing their relationships with the humans inhabiting the home and calling them a friendly group of phantoms. But Shitoplasm really only hit the fan when the house went up for sale, eventually leading to the case of Stambovsky vs. Ackley, or what's known today as the Ghostbuster Ruling. The story goes that when Ackley put the house up for sale, she hired a real estate broker by the name of Eris Realty, who then came across Jeffrey Stambovsky, a New York resident who was unfamiliar with the Nyack folklore and the reputation of the Ackley home. Jeffrey Stambovsky, who I'm gonna be calling Jeff for the remainder of the video, made an offer for $650,000 as well as a down payment for $32,500 before discovering the colorful reputation of One Lavetta Place. Since the ghosts were unlikely to help with the mortgage payments, Jeff was understandably not too keen to share his home with them and tried to rescind the sales contract as well as to get his $32,500 down payment back without litigation. But since the realtor wasn't really happy about losing her cut of the deal, Jeff's request was denied. And so he had to bring his complaint to court, everyone's favorite place, where he also requested damages for the fraudulent misrepresentation by Ackley and her real estate agent. The initial complaint was dismissed by the New York Supreme Court on the common law doctrine of caveat emptor, meaning not my problem in Latin. Caveat emptor is actually a legal doctrine that places the burden to reasonably examine the property before making a purchase on the buyer, and the buyer who fails to meet this burden is unable to get compensation for defects of the purchased item if said defects would have been discovered had this burden been met. In normal words, Ackley didn't have to disclose information about the hauntings to potential buyers, as it was the buyer's problem to dig up that information. But was it really? Yes, it is the buyer's duty to reasonably inspect the property, fair enough. But let's not forget about a very specific word that is very important when it comes to the law. Reasonably. Sure, you might want to check if there are cracks and mold on the walls, maybe even signs of flooding in the basement, but what is really the extent of a reasonable inspection? Hi, I came to take a look at the property. Hi, great, do you have like an architect or an engineer with you? Do I ever? Come on, boys. That's my structural engineer, my plumber, my lawyer, my cousin Vinny, and a girl from the orphanage who likes to play with a Ouija board. Hope you don't mind, just in case. After losing to the Not My Problem defense, Jeff appealed the court's decision and did so with resounding success. In a majority vote, the appeals court found that caveat emptor did not apply to Jeff's case, as applying the strict rule of caveat emptor to a contract involving a house possessed by poltergeists conjures up visions of a psychic or medium routinely accompanying the structural engineer or terminix man on an inspection of every home subject to a contract of sale. Or in other words, who the fuck inspects a house with a psychic or a medium? The specific nuance which allowed the appeals court to overturn the initial ruling consisted of Ackley's monetization tactics of promoting the house as haunted so far as to earn an article in Reader's Digest as well as multiple appearances in local newspapers. Given that One Lavetta Place was considered haunted enough to be a stop on a tour of haunted houses, as well as the unreasonable extent of an inspection that could kinda reveal the haunted status of the home, the appeals court found that such a reputation must be disclosed by the seller itself in what I can only describe as an interpretation that leans less towards the letter of the law and more towards the spirit of the law. The court allowed Jeff to get rescission of the contract, sparking some pretty serious legal debate about the reputations and histories of homes, which can be haunted not only by ghosts, but also by the tragedies and misfortunes that have happened within their walls, as with this gorgeous property responsible for the founding of Amazon. These are best known as stigmatized properties, and the law generally views this as more of a psychological defect rather than a physical one, with only the physical ones warranting disclosure and remedies. Because who wouldn't want to unknowingly live on a site of atrocities like the Manson family ranch or Mar-a-Lago? Nevertheless, the house was later sold to another buyer and Ackley moved to Florida in 1991, claiming that she was taking the ghosts with her, although after her death in 2003, her son-in-law would lay odds that her spirit has taken up residence back at La Veta Place, where I guess she now spends her days having tea with the lieutenant. So, what have you learned today? To look up a house's history before buying it? To inspect it with an orphan so I'm not bound to live with ghosts by a contract? No, Alex. The answer to all things legal is always it depends. The only thing that does not depend on what it depends on is that you should all subscribe to the channel right now. Now go back to your feathered overlord before he sues me.